So today we are going to address codification. Right. So what we have done is we have understood the distinction between the definition of law, international law, approaches to international law, the distinction between international and private law, the like the various phases that international law has witnessed over the course of its existence, and then the approaches, right? Like positivist approach to international law, and then the naturalist approach to international law. Both have significance, both have relevance, and both are coexisting in the larger framework of public international law. But they have also developed a kind of arguments, right? When you have positivists who argue that state alone and their practices alone are the basis on which international law has been like formed. Then you have another school, natural law school, who says that much like individuals, states are also under certain obligations. So mere existence of a state and their practices do not serve the purpose of international law, but it is something when they've been following the inherent rights, the inherent demand, the reasons, when they have been reflected in the manner in which states have been preparing their laws or been following certain practices, then there is something called international law, right? Otherwise, anything merely being an activity of a state will not be suffice enough for becoming an part of international law, right? There has to be odd propositions as well. Reasons must be also attached, right? Something external to just making of law must be present. But this particular debate also strengthened the argument of codification of international law, right? Now, when we refer to the term codification of international law in the UN Charter under Article 13, Clause 1, Subclause A, there is a reference called progressive development of international law and codification. Now, there had been doubt with respect to use of that phrase of progressive development of international law. Now, what does one believes as to be progressive development of international law? It is something which is not yet has been developed in the form of practices that states have been following, or is something which is not present in the domestic setup of any particular state as well. So this is what is progressive development of international law, meaning thereby what is going to be there in the future, right? And there had been great amount of debates. Just a second. There had been great debate amongst and between the states when they were framing the draft of UN Charter, United Nations Charter, and most of the states, majority of the states for that matter, were quite apprehensive to this use of the term progressive development of international law, right? They believe that this is something which will ultimately undermine the importance of state practice altogether. That largely the international law is centered around state practices, be it in the form of customs or in the form of treaties, in the form of agreements, in the form of other sources, right? So this will ultimately undermine something which has not been in the practice of a state, which state has not been involved into, could not be and should not be part of international law, right? So that was an argument, and ultimately what happened is a different understanding altogether. We'll come to that particular part during the course of our understanding of codification of international law, right? Because there was a middle path which was followed, and that middle path is what is your Article 13 of UN Charter, right? And it's a very important provision in the UN Charter itself, right? More in detail, you will be learning about your United Nations in your international organization subject. But we will be referring to United Nations more than often, right? Not just at one place, because it's a very important organization altogether, especially in the present times, having a status of international organizations, not just status of international as a status of international organization, but also habitually being involved in making of laws, right? And involving states for that matter. There have been tremendous efforts on part of UN. Recent years, there had been debates and there had been works also coming, like academic work, scholarly work, wherein they've been like revisiting the need of UN Charter, United Nations, or been understanding what United Nations as an institution has done for the past more than 75 years now, right? Since its making. There are differing opinion. Critics believe that it has lost its purpose, right? The world is not being governed, or like it has lost the very purpose for which UN Charter was formulated or United Nations was, like thought of, right? But there are others who believe that its significance has only grown over the years, right? Many believe its significance has lessened. Some believe that like it is one of the reason why their argument of not treating international law as true law like holds good ground, because when you'll undermine the very basis, the most basic institutions of international law as redundant, it serves your purpose, right? But then the point is, if you look into your materials, like class material folder, unit 1 folder, I have referred a reading whether international law should be treated is a true law or not. Read that particular material, right? It will give further clarifications to any doubt if any person has to the relevancy of international law, right? Because this is the most important aspect. World has gone beyond that particular doubt now, right? But we are still teaching our students whether international law is true law or not, right? That generally happens during our times in like when we were studying international law in Delhi University. We had a sure short question, right? I'm not aware of the latest development, but this was a question which definitely comes in the finals, and we had already prepared our answers in that particular regard, right? So but the world is not discussing whether international law is true law or not. They have been discussing something beyond this particular question that has lost all its significance as a question altogether, right? But do read that particular paper if there is any doubt with respect to the nature of international law, right? But now coming to codification part, it involves three processes, and why codification became so important. There's a history behind the lobbying for codification of international law, right? When, as and when international law, and Stark was to a great extent correct in this regard as well, that the major part of international law developed around 19 in the 16th 17th century. It has nothing to do with the history. One of the reasons why he has been arguing that particular like issue is because codification, because the effort towards codification was first initiated by Jeremy Bentham in his work Principles of International Law, wherein he defined international law, coined the term international law, because prior to him, there any reference to international law was being considered in two forms: law of nations, and then like conflict of laws, right? Those are the two things which were referred for anything which is what we have been understanding by the term international law. So Bentham made this effort of coining the term international law, but also defining international law, at the same point of a time proposing to the state that there should be efforts toward codification. Now, in this particular efforts toward codification, he uses utopian spirit, the utilitarian spirit, right? Let the state come together and have a consensus on their own. It cannot be enforced upon a state, right? Because consent, he look at to his definition. He said that the primary source of international law is state and state alone. They are making the law. Customs at that point of a time were quite prevalent. Treaties were also been emerging, right? But custom was largely, and he believed that it is only the state, and state being the sovereign. Treaty of Westphalia has already like strengthened that argument that states are sovereign, cannot be undermined. So you cannot compel a state to agree to a particular practice, but what can be done is on the basis of consensus, right? So if there are consensus among the state and they agree to come to terms of codification of international law, that can be a possibility. This is what he has argued, because he also argued that the environment at that point of a time was vitiated by political strains, tensions, stresses, strifes, and those were quite common, right, during his time. That he was unwilling to come to the terms that state would ever go for this particular proposal. But he made a proposal that this will surely help the state in understanding a law in more clearer terms, right? So this entire process, and this is a period when in Britain also there was this debate for going for international law, right? No, not the debate for going for codification of law was at the highest, right? And that ultimately resulted in the world altogether, the state of Britain to test codification of laws. And as a testing ground, India was, like one of those testing grounds. Like they initiated efforts on behalf of Law Commission, establishment, and thereafterwards the the process was all towards making of laws. The results were good enough for state of Britain. They also followed similar practice in their society, and they found out that when laws have been codified into black and white, they it becomes easier for a state to and for people to understand laws and for state to enforce those laws. Right. So understand it from that particular perspective. So what are those three processes that codification looks into, especially for codification of international law? It will collect the rules which are dealing with a particular subject and will put it into orderly or logical manner. Say, for example, with respect to law of sea, right? There are various customary practices which were followed among the state with respect to territory, with respect to involvement of flagship, with respect to use of resources, with respect to like uh, allowing safe passage to another state, with respect to like capturing of an offender, with respect to various others. These were all customary practices which were in existence prior to the formation of UNCLOS, right? United Nations Convention on Law of Sea. But what does this process of codification did? It put all of those customary practices into a logical manner, right? And if they found any defects in this particular practice, those will be removed, and these will be rephrased. Either they will be removed, they will be rephrased, or there will be altogether a new provision that will be referred, incorporated. Right. The third process, so that's the orderly and logical manner. Second is remove defects. So if there are any defects, say for example, because my larger focus is always on law of seas, so I will be giving more examples from law of seas rather than any other particular area of international law. So therein, the defect is that states were not having similar practices with respect to extension of territorial boundaries. India was following 3 nautical mile rules. US was following beyond 12 nautical mile rules. Other states were following 6 nautical mile rules. Some states were following 9, some were following 11. Some have not decided on it, and they said that it will continue till their continental shelf, right? Continues to the continental shelf, right? So there were defects, there were, and codification removed those defects because it settled for once and all that the extension of territorial extension of any particular state over the waters shall be extended maximum up to 12 nautical miles. This has been settled by the United Nations Convention on Law of Sea. So it removes defect. Third aspect is it becomes a, the enactment, such enactment becomes a set of rules which are binding upon state. Right. This is an important aspect, and this is something which is part of codification but has been handled differently. So your United Nations Convention of Law says are only enforced against signatories or parties who have put their signature to that particular convention. You cannot enforce the provision of one clause against a state who is not party to it. You have to establish a case of jurisdiction in such a situation, right? So this is a very important aspect of international law that you will, on the basis of putting them into orderly manner, in a logical manner, with removal of defects, you will put it as an enforcement against the states, right? So codification was a very tricky issue for international law, and it continues to be a tricky issue in even today's time. Say, for example, like International Law Commission, which has assigned to itself as the first like when there is any institution which has been established, it establishes certain like projects for itself that they will be involved into. The project with respect to state responsibility was something that was formulated in its first meeting itself, in the first meeting of International Law Commission itself. But this is something which has not yet has been fructified into a proper form of convention. Still, there had been efforts towards like clearing or working of that state responsibility. Initial drafts saw criminal liability of a state, civil liability of a state. The criminal part liability of a state has been removed. Now all that has been left is the civil liability of a state, for which also there have been efforts ongoing, right, to further clarify that particular part. So there are certain efforts which are still ongoing, right? So International Law Commission is still working on it. Otherwise, International Law Commission has various successes as well. You have United Nations Convention on Law of Sea, you have ICESCR, you have ICCPR, various conventions which have been formulated under the aegis of United, like your International Law Commission. And since its inception, there have been more like organizations which have been working on the draft proposals or for preparation of models for like any particular like binding rule or codification of international law. UNESCO is another example. So you have International Law Commission. UNESCO also works on similar lines, right? And it has also contributed immensely towards codification of international law. So much so there are other institutions as well. So this is what is codification of international law revolves around these three principles. Who initiated this? Jeremy Bentham. When in 1786-89, right, under his work Principles of International Law, he for the first time proposes to the world that there should be efforts towards codification of international law. He followed utopian spirit, the reason being the sovereignty of a state remained at the highest pedestal. You cannot compel a state. All that you can do is that you can like wait for consensus among the state. But that argument was initiated at least, right, by Bentham. Now this is also followed because at that point of a time, when you are studying international law, understand it from the perspective of the then prevailing circumstances, and most importantly, politics. Right, politics plays a very important role, and this has been significantly conveyed by Bentham. Right, because he said that why this is difficult, right? Because there are political tensions, there are strains, strifes, and stresses that play a significant part under international, like politics, right? So this is something which needs to be taken care of. But nevertheless, if codification like does takes place, because it was merely a proposal, his hypothesis was that if it does takes place, it will definitely benefit the world. So an argument was made on behalf of Bentham that there should be an effort toward codification of international law, which is what largely been scattered in the form of customary practices or treaties that were emerging at that point of a time. There was another effort. So if Britain, through its scholar Jeremy Bentham, comes up with this particular proposal, you will have other states also coming through their proposal, like their scholars, and like an argument for codification. So you have French Convention, particularly their Declaration of the Rights of Nation in 1792. An unsuccessful attempt was made towards suggesting to other states that codification shall be made, particularly with respect to rights of nations, if they can be established. And they suggested a draft, which was not accepted logically, right? States are not willing at that point of a time to accept such proposals, right? But an effort was made. So if there is a very interesting event of Treaty of Westphalia, like being made, the second important attempt with respect to the further, betterment of international law, if I may say, is this Declaration of Paris, 1852. It's a very important declaration. A lot of books of international law of great scholars will emphasize on this particular declaration. It's a very relevant declaration, very important declaration. People do not give much, especially students do not give much attention to this declaration, but it is a significant development similar to the development of that Treaty of Westphalia. If Treaty of Westphalia ensured territorial supremacy, right, of the states, This declaration ensured the progress towards the argument of codification of international law. Now, this has been signed by Britain, France, Austria, Russia, Turkey, Prussia, and Sardinia. Right? These were the countries at that point of a time. So, and each of these states declared that they will not be involved into privateering, right? Private wars. They will not be involved into capturing of goods. They will not be, unless and until, right? They will not be involved into capturing of enemy goods, right? Or involved into illegal imports of wars and other things. So certain agreements were being understood among the state. Privateering is private wars, right? Because Treaty of Westphalia suggested to the state that if they have been considering themselves as a civilized state, they must not be involved into these kind of activities, particularly the activity of war. So what has been like an alternative that developed at that point of a time, the state will not directly enter into war, but since there was so much of a competition with respect to obtaining of resources, they will be like supporting certain private warlords, and this has been done as a regular practice. But in 1852, this was accepted among these states that this is something which we need to discourage, right? We should not be supporting these private wars of for disturbing the goods of others, for encouraging transport of war-related materials amongst ourselves. So this was a remarkable achievement, right? And there are other remarkable achievements of this particular declaration, right, which we'll be covering later on, right? When study, we'll cover this particular aspect. But remember, much like your Treaty of Westphalia, Declaration of Paris is a very important, remarkable effort. Now, proposal was given by Bentham. There was an effort by state. There were these declarations emerging. Now, this is a period when, like, remember when in the earlier class I said that second phase is a phase when international law gained greatest of its momentum. So press, and one of the reason was press, of course. Renaissance was another. So press was also one of the reasons. So what was happening? There was exchange of these documents amongst the states. Scholars were suggesting and coming up with this argument. So initial effort was made on behalf of scholars. Bentham was definitely been there, but there was an Austrian jurist. I will not be recollecting the full name, but Alphonse von Domino, if I'm correct enough. He also suggested that there should be an effort towards codification. There were others, like scholar who was Francis Labour, right, in US. Now he also suggested that there should be some efforts toward codification of law. So scholars were arguing for this particular argument, for this particular view that codification of like international law should be initiated. Remember, this is and this is 1852. There were Hague Convention, which started from 1889 and continued till 1907, right? Hague Conventions, which is for pacific settlement of international law with respect to customs of wars and all those things. And it's a very remarkable convention. The result of those Hague Convention compelled to the world that there can be a possibility of cooperation. There can be a possibility wherein the state collectively can sit together and come to certain terms, consensus-based terms. And that ultimately resulted in making of League of Nations and followed by its failure to the formation of United Nations, right? But Hague Conventions are very important for that particular purpose, and they also contributed immensely towards codification of international law, right? Hague Convention from 1889 to 1907. It involves, like pacific settlement, law related to wars. You will also have, majorly centered around law related to wars, naval force, in territory, in land and sea, all those kind of things. So Hague Convention for that particular purpose is very important. Whenever you are studying any subject, the history of that particular subject is quite relevant and interesting. Right now, scholars have been arguing this across the world. You have an Austrian, scholar, jurist, like Alphonse von Domino. You have an American scholar, this Lieber. Then you have Oppenheim also, Hall as well, Bentham already from Britain, Hall from Britain, Oppenheim, all these scholars been arguing for a case towards codification and been suggesting different opinion and arguments, right? Now you had a very important development again. Now, Charles Hughes, he was the president of American Society of International Law, made an address to a gathering. And therein he suggested that attempts must be made on behalf of individuals, societies, and governments towards codification of international law. Now, this was a time when America was becoming a developed state. Now, one of the what you call the signs of a developed state is when you have better institutions, commanding institutions which have been not just been accepted as an institution by the state itself, but by other states as well. So, American Society of International Law was been a very reputed society altogether, and majorly many scholars, great scholars of world wanted to be part of such gathering. Therein, this particular proposal by the then President Charles Hughes made a significant contribution towards arguing for a case of codification of international law, right? As a result, there were significant number of institutions also emerged, and they also supported the proposals which was initially been given by scholars, supported by institutions like American Society of International Law. So new emerging institutions emerged. You have Institut de Droit International, which is in France in 1873. At the same point of a time, there was International Law Association, which was established in US in 1873. Right, both of these two institutions came up at the same point of a time. Right, and this Institut de Droit International is a very reputed institution in present times. Comes up with various courses and others, and have membership of great scholars across the world. From India, I think it's roughly around 3 to 4 people who are member to it. Right, of this very reputed international institution. It's a matter of prestige if you have been member of this institution. Right, and there are various requirements in that particular regard to become a member of this particular institution. Right. So they sent proposal to their respective government or to bodies like international organization, right, who are playing significant role towards lobbying as against codification, right? But there was a remarkable effort which was made by Howard Research in International Law. That's a very reputed society which made and played very significant role in the making of UN Charter for that matter. Right? That's why you are learning about an institution, learn its history, how it has been involved, right? What all were arguments were made in favor of, who opposed, right? So we have to, yeah, who opposed, and what were the solutions that were assigned. Say, for example, with respect to this Rome Statute, right? The US and Israel state governments, they were ready to be accepting that particular convention in the initial days. In fact, they have supported that efforts towards establishment of international criminal court. But later on, as and when they were going through those particular provisions, they found it difficult, right, for them to protect or their interest. So what they basically did is they made every efforts to make to delay this entire process of formation of international criminal court. They were always there was a great amount of lobbying on behalf of various states, including US and Israel, to stop this process of formation of international criminal court, which initiated roughly around in 1993-92, right? And ultimately the world was quite aware of this, because it was quite at that point of a time, the world has witnessed so many of wars, so many of issues which requires global attention, right? In fact, if you look into the year when the adoption of Rome Statute was formally being made, the then Secretary General Kofi Annan's observation is quite relevant and has been openly quoted in many scholarly work, right? It's a great achievement. So this is quite interesting as to what all states are in favor of, who are against, what all efforts state have made towards its development. All of this is quite important, right? So when you are studying something in international law, international politics, international lobbying, diplomacy, all plays significant role for its development, for its existence for that matter. So these institutions, and remember, each of these institutions are quite reputed institutions, right? Especially these institutions, they Deloitte International, right? So they made various attempts, particularly in the form of arranging diplomatic conferences, because one of the easiest and short way of lobbying for international any new development in international law is that you approach the developments diplomats of various states. Largely this is centered around diplomats only. In fact, in recent years there had in India also, whatever document we have been submitting to those international forums, those have been submitted through diplomats itself, right? We generally do not place over there any for assistance. Of course there will be certain guidance that will be provided by academicians, but by and large this is something which is centered and worked around diplomats alone, right? So diplomatic conferences were initiated by these institutions, and they ultimately suggested to them that there can be a possibility of multilateral conventions, adoption of multilateral conventions. Hague Convention, in that sense, is a remarkable achievement. Again, I'm saying, starting from 1889 to 1907 was a remarkable achievement towards furthering this argument of codification. It was a multilateral convention, but it gave you know, like a kind of sense to states that yes, they can sit together and come to certain terms, codified terms, and they can be binding, right, to those parties. That there can be a possibility. So all of that has been done. Now, this aspect, and I've been skipping in between period between what happened in League of Nations, and at that point of time, what was the observation of such countries with respect to codification and progressive development of international law. I'm largely been coming to the UN Charter itself. Now, when this Charter of United Nations has also been prepared, it was again a very rigorous process. Many states were opposing this argument that United Nations should be given this right of, or this power of legislative nature, right? Because we are all sovereign states. We have all come here with on the basis of this principle that sovereignty cannot be undermined. But if we'll give this power of legislative power to United Nations, that will ultimately undermine our sovereignty, right? Because they will become the United Nation will become a super nation, right? Amongst all the nation, a super nation, right? So they were opposing this particular right, that if there will be any possibility of codification of international law, it must not be done under the aegis of United Nations. This is one of the opposition which was found when the Charter of United Nations was prepared, right? Another observation was that they do not want, majority of the states do not want that the power to impose general conventions on the state should be conferred upon General Assembly. So wherever you will find this GA, General Assembly, right? So there was another this opposition to this particular proposal. So you will have proposals framed on behalf of states who are preparing, who are arguing for such provisions, and then you face oppositions, right? And then there was a middle path which was agreed, and that middle path is what is your Article 13 clause 1 subclause A of your UN Charter, right? Which conferred General Assembly with limited power, right? And that limited power was studying of international law and granting of certain recommendations. Now we all know that General Assembly recommendations are non-binding. So if there are certain recommendations which have been assigned by General Assembly, if a state doesn't follows those recommendations, it doesn't lead to repercussions, global repercussions, or group, uh, so. But they have over the years, like if somebody has studied the history of United Nations or is a student of international law, this should be understood that over the years, the recommendations of General Assembly have obtained the status of soft law, right? which is non-binding, but yet they are quite crucial for states to follow, right? So General Assembly was given with a limited power, and over the course of a time, this is something which you will learn, like while you will be studying international law or understanding international law from holistic purpose. You will learn more about it, but we will cover this distinction of soft law and hard law because recommendations of Security Councils are binding. No country can argue that these are not enforced, they cannot be enforceable as against them. Those are binding. But for General Assembly recommendation, non-binding but acting as soft law. We'll cover that particular part as well later on, right? But since the entire jurisprudence, and I will give you examples with respect to soft law, there's an entire jurisprudence pertaining to environmental protection across the world. The international environment law is based on soft law. States who are contributing, like immensely to the, like to the against the cause of climate change. There are no like measures that you can take against such a state, but indirectly the state will be held responsible. There are various mechanisms that have been drawn which will make state answerable, right? Though cannot be enforced against that state, but ultimately it will result against that state, right? There are various forums wherein you can like raise a complaint against a state. The entire jurisprudence pertaining to WHO, again centered around soft law. The entire jurisprudence pertaining to human rights. Now, human rights is gaining importance. In the recent years, it's been gaining importance, but again, on a generally speaking, I will say it's fit it around soft law itself, right? But it has been gaining importance. There are various measures that has been adopted by world altogether for enforcement of human rights, not just as against states, but also against businesses. There's this new subject emerging, business and human rights, right? Wherein there are new proposals wherein it has been compulsory, not directly but indirectly, it has been made compulsory against states that they should follow human rights, right? And there are various policies that have been adopted by many states. So in order to your company being listed in London Stock Exchange, you need to submit yearly basis of human rights report, right? And if there can be, like, so it's becoming important, and it's a matter of prestige for companies to get listed in London Stock Exchange, right? Or for that matter, New York Stock Exchange. So for that, businesses have been compelled to come up with their human rights report, right? And if they've been not submitting their reports on a regular basis, and if there are cases filed against them, many other aspects, they will put them into a certain categories and ultimately will remove them. Right? So all those aspects. So business and human rights, the new subject altogether coming, but again in a direction of enforcement of that particular, like a requirement, acting as soft law, right? So those are examples. So yeah, coming back to this, that General Assembly has been given with a limited power because states were having objections both with respect to this particular requirement that power of legislative nature will be assigned to United Nations. Second, enforceability, right, of the recommendations which have been given by General Assembly. So a middle path was that Article 13. Now General Assembly shall initiate studies and make recommendation for the purpose of promotion of international cooperation in political field and encouraging progressive development of international law and its codification. So the task of progressive development of international law and codification has been assigned to General Assembly. Now, because of this particular task, there was a resolution passed, and before that particular resolution also there was a lot of development that took place, which ultimately resulted in the making of International Law Commission. So we'll come to that particular part in coming classes, right? Any doubts if anyone have so far for what we have covered? Are there any doubts? Read this particular provision, Article 13, Clause 1, time and again. It's a very interesting provision because it says that General Assembly shall initiate studies and make recommendations, right? So if there is anything with respect to promotion of international cooperation, recommendations will be provided to states. The binding nature or non-binding nature of those recommendations is something which has to be understood differently. If it has attained the status of soft law, it will be binding upon state, but indirectly. But if it is merely a recommendation, non-binding, right? So in the political field, to encourage progressive development of international law. So General Assembly has the power to develop a domestic law of a particular state if it does not have if it has not developed it as per the requirement, the modern requirement. Because in the early part of today's lecture, I was referring to the term progressive development of international law. Many states raised objections with respect to use of the term progressive development of international law, because they were of the belief that only states can make law, right? So an agency of United Nations being given this task of preparing new law for the future is something which will undermine the very basis on which international law centers around, right? That's the most important basis on which international law centers around, that the state becomes the primary subject for preparations of international law. So, and progressive development of international law is something which has not been prepared or is not being found in the practice of a state as of today, or in the domestic laws of that particular state as of today, and can be a possibility in near future. So they will suggest to the state that these are the things which you can work upon in the for your near future, because this is what is going to be the usual practice of a state altogether in near future, right? So this is very important. And codification, right? So it's codification. So somebody has to work upon those particular principles, right? You need to codify it into certain black and white letters, so that state who are party to it shall be enforcing those particular provisions in their practice as well as in their laws, right? So this is what has been referred under Article 13(1)(a). Then we'll move to the next part of our class, wherein how, because of this particular provision of Article 13(1)(a), the emergence or the establishment of International Law Commission, not International Law Association. We have referred to the term International Law Association. That's a body altogether different, which contributed significantly towards this argument of codification of international law. International Law Commission is a statutory body. It is a body which was instituted under the aegis of United Nations, right? How it came into an existence, because this was not been there in the initial years. When United Nations Charter was accepted, you do not have reference, you do not have finding of International Law Commission over there, right? But it was formulated and established late in the later years because of the use of the term, reference of the term Article 13(1)(a). We'll cover that particular part in the coming classes. Any doubt? Okay, any student who joined late and has not been marked?
Yes,
Yeah, just
054 right now.
okay, beta.